Well, welcome and thanks for joining the TuckerAllen Virtual Town Hall. I'm Scott Trout. I'll be your moderator for today. And we're going to be talking about estate planning with a purpose. And I thought about that title, and it really is for a purpose. There is a purpose. And we want to break down with our panel of TuckerAllen attorneys, really estate planning. Don't forget, we're going to have a lightning round with a question and answer session in the second half of our town hall. Utilize the Q&A section in your Zoom technology. You can submit a question. We'll get to that. Put your first name and kind of where you live, and we'll make sure we get that to the attorneys of TuckerAllen in our second half. Again, use the Q&A section. You can do that right now. We already have some pre-submitted questions that we will be reviewing. If you don't want to submit a question, but you yet would like that question answered, you could submit those to TuckerAllen.com/questions. So TuckerAllen.com/questions, and we'll address those in the weekly podcast that we do at TuckerAllen.com. And so you can check those out and all the other videos and other resources on the website, and you get more information. We'll spend just an hour today trying to break down and simplify some of the estate planning questions that you have and make it a little bit easier to understand and take some of the stress away. As I start every podcast and virtual town hall, this should not be a substitute for a consultation with an attorney, and obviously your facts and circumstances would likely dictate additional information. So this isn't really an attorney-client relationship, and do not take this as legal advice. This is really talking points for us that you can take to an attorney, and hopefully we can answer some of your questions. But again, you need to make sure you schedule a consultation with someone who practices exclusively in estate planning and elder law. And so you can do that. And certainly the attorneys that we're going to be meeting today at TuckerAllen are available for a consultation. You can schedule a consultation online at TuckerAllen.com, or you can give them a call at 866-335-3375 at any of the offices that we have in Illinois, across the river in St. Louis, Kansas City, and in Overland Park, Kansas. So before we get started, we want to go ahead and introduce to you our panel of attorneys today from TuckerAllen. Let's start with Missy Manning in St. Charles. Welcome, Missy.
Hi, Scott. Hi, everyone out there. As Scott said, my name is Missy Manning. I'm an attorney in St. Charles. Just a little bit background for me. I graduated with highest distinction from the University of Kansas, and then I crossed the border and I graduated cum laude from the University of Missouri School of Law. And I've been practicing estate planning for about 7 years now.
Thanks, Missy. Let's go to Teresa in our Kirkwood, which is just in the St. Louis metropolitan area. Welcome, Teresa. Yeah.
Hey, thanks for having me today, Scott. Yes, so I am the attorney for TuckerAllen in our Kirkwood office. And I guess a little background about me. I went to Washington University where I got my bachelor's degree, my law school degree, and my social work degree. And I really think my social work background helps me relate to my clients in a meaningful way.
All right, thanks, Teresa. Going up to Overland Park, Kansas, just across from Kansas City, Ryan Foley. Welcome, Ryan.
Good afternoon. Thank you for having me. As you said, my name is Ryan, and I am the attorney who goes back and forth between our Independence and Overland Park offices. I graduated from law school at UMKC, grew up here in the Kansas City area, and licensed in both states. Happy to help you either way.
Thanks, Ryan. And rounding out our panel of attorneys at TuckerAllen, let's go to Kevin Mason in our Kansas City Independence, Missouri office. Welcome, Kevin.
Hi, Scott. Thanks for having me on today. I graduated from MU Law, and now I reside in the Kansas City area.
Great. Thanks, Kevin. Well, we're anxious to get started. I know everyone wants to hear more information about estate planning and kind of breaking it down, and we're going to get to that. Again, as I mentioned, submit your questions in the Q&A section. I've already got a couple questions coming in. We're going to get to those in the second half of our virtual webinar today. If you don't want to submit it online, but yet you want us to answer that, you can always do that at TuckerAllen.com/questions. And also, as I mentioned earlier, there's a bunch of resources on our website, videos and other podcasts that you can go to at TuckerAllen.com, hitting the tab resources. But before we get started, let's go ahead and take a real quick break, and we'll be right back.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
All right, welcome back. Let's get started. Really, we've talked about estate planning with a purpose, and I think now more than ever, what's been highlighted today is with this pandemic and COVID-19, it's really emphasized to me and to I know a lot of others who have emailed and called TuckerAllen with questions about what to do now. Many times you think about estate planning and you think, oh, it's, I'm not old enough, or I don't have enough, or I'm too young, or, I just had kids, or I don't have kids. Well, I think the point is, and we're going to talk even about college kids, there's some instruments in estate planning or even through that really should be considered. And it's really shed a light on estate planning and what we should be doing now. And, if not now, when? And that's really the question. But Ryan, I want to start with you and really talk about some of the vital things that people should be thinking about, maybe the documents that everyone should have. We want to break it down to kind of, a lot of people listening and watching right now are familiar with estate planning. They may already have some documents, and we're going to talk a little bit about that as well, and what they should be doing, even if they've already planned. Like I'm a client of TuckerAllen, and I had things done 25 years ago, and it was time to update it. And really the tax laws have changed, things have changed, the provisions, but Brian, break it down. What are the vital documents that people should be thinking about and they could write down right now?
Absolutely. You've touched on some great points there about your documents needing to be current as well. Now, what makes up an estate plan typically needs to include power of attorney documents, both for healthcare and for financial. You want a living will. Sometimes you'll hear that referred to as a healthcare directive or an advanced directive. They're the same thing. You still need it. You need a HIPAA release, generally a good policy to have that. You want your last will and testament, and you want a trust. And in most situations, you're probably going to want a beneficiary deed as well.
So, there are many people that are watching from around the world right now and have questions. They may have documents. Is it better to have old documents than no documents? Did you mention some of those?
Oh, absolutely. It is better to have something than nothing. And it's better to have even just a few documents than no documents at all. It's best to have a full cohesive set that have been made at the same time and that you've kept current. But having something is always better than having nothing. You can always fall back on the state's plan, but it's best to have your own.
Yeah, and we'll talk about kind of the fallback and what happens when you don't. And, I mentioned, the COVID-19 has really changed the way we look at it. You used to think, well, I've got plenty of time. I'm not sick. I don't have any issues. Now it comes out of nowhere, especially which we're going to talk about some of the instruments and documents that you probably need separate and apart from a will and a trust that, in the event that you become sick or, we talk about these ventilators and people getting put in the hospital, which is crazy. But there are people right now that, Ryan, that have documents, but maybe things have changed. Obviously, is it better to make some changes if, for example, they had their parents listed or now they're married? Is that something they can do to make changes?
Yes. A good rule of thumb is that if you've had anything that you would consider like a serious life change, you probably need to update your documents. Now, there are things that you can't track. You said like your documents were 25 years old. That's probably going to need to be changed. You said, there's been tax changes. We've had things like the Secure Act get passed, but life changes happen as well. You've gotten married, or someone has passed away, or you have children now. There's been a divorce, even of one of your beneficiaries, and you want to make sure that the things that you're passing down stay with your family, not whoever the ex-spouse remarries. It can get that complicated and that nitty-gritty. It's very important to make sure that if something in your life changes, that your estate plan keeps up with that.
Yeah. Missy, I want to talk about it can become overwhelming. And there's a lot of things we talk about and the words we throw out. I want to talk about where do we start, but remind everyone, submit your questions now to the Q&A section. We're going to get to that in the second half. As we're talking about these things, write your questions down, submit them. We'll try to clarify some of the topics that we've addressed, and we're getting some questions as we go now. But again, in the Q&A section in the Zoom technology, go ahead and submit that, and we'll get to those in the second half. Missy, so maybe this is, we talk about, when we die, what happens, and wills and trusts, but where do we start now while we're living? We've heard of things called a durable power of attorney, durable power of attorney for healthcare. Is that where we start, and what do we do with those?
Those are a great place to start. Those are the two documents that everyone age 18 and older need to have on hand, no matter how wealthy or not wealthy you are. So the big one is a financial power of attorney, also called a durable power of attorney, but for simplicity, we're just going to call it the financial power of attorney. And it makes someone have the right to make decisions for you when you're incapacitated about paying your bills or selling your house if you're moving into a nursing home or something along those lines. A healthcare power of attorney nominates someone to make healthcare decisions on your behalf when you're incapacitated.
Mm-hmm. It's interesting. You don't think about these. And like I said, I keep bringing it up. COVID-19 has made me personally rethink it. And we've had our families had someone die and pass away. And we were in the hospital, and there was a question about who should be making the decisions. And fortunately, they had executed that healthcare power of attorney and nominated someone. And I had decision making and my thoughts. And I have a daughter who's a nurse, and I think she's more equipped to make those. And it takes the stress out. And these are the things that you want in place when you're alive right now, as opposed to planning for your death, right?
Correct. So getting something set in place now in case of your incapacity is half the battle. Planning for after you pass away is really important as well, but we want to attack both angles, just especially right now in the COVID environment.
And those apply to, you said 18 and older. I mean, it's real easy for us to get caught up before this pandemic thinking, well, I'll wait till I'm getting close to retirement and then I can execute it. I mean, these are things for which really we now know, I think everyone, first responders, frontline workers, especially if you have kids, right? These are important documents to get in effect now.
I totally agree. So for example, my husband works at Costco. So he sees people all day long, every day. They do have a mask policy there, but it's still, he's considered very high risk. So we worry about that constantly. And I'm sure lots of other people do as well in that same position.
So you don't have to do the whole thing, right? You can just have the durable powers of attorney executed and the healthcare and not do anything else, albeit it may be something that's important to do. But for those watching right now, they can think, okay, I can start somewhere, right? I can start with these two instruments.
Absolutely. So it can be very overwhelming to think about having to do a whole estate plan and all the documents that Ryan listed off. Let's start with the basics. Let's get two durable powers of attorney, one for healthcare and one for finances, just so that you're covered if something does happen to you and you're incapacitated.
Great. All right. So Teresa, we're talking about these. Maybe we can explain them a little bit better so that people understand kind of why it's important and what do they actually do. Kind of explain first the durable powers of attorney.
Yeah, absolutely. So as Missy was saying, the durable power of attorney, we oftentimes just call it the financial power of attorney because it just makes more sense that way. What it does is you're sharing your financial decision-making powers with somebody else, whether you're incapacitated or not, and you can make that judgment call about when you want that agent to really start being able to act on your behalf. And normally what this financial agent can do for you while you are alive is, help you pay your bills in case you're not able to, or help you invest. They can make a pretty wide range of financial decisions on your behalf. And it's pretty obvious how it can help you when you're incapacitated, right? You want somebody to be able to step in to act on your behalf when you're unable to. But it's also really helpful when, even though you're capacitated, but let's say you leave the country for a certain period of time and you just need somebody back home to take care of your assets. A financial agent is a great person to do that. And then pivoting to a healthcare power of attorney, like we've been saying this whole time, now more than ever, a healthcare power of attorney is critical. And how I like to kind of frame that mindset in terms of appointing a healthcare agent, I like to tell my clients, think of the person that you think shares the most similar values to you in the whole world and would make the same decisions as you would make with regards to your health and your body. And that might be a different metric. You might have different agents for your financial power of attorney as your healthcare power of attorney, and that's totally okay.
So on the durable powers of attorney, and you and I talked offline, it really was something that I missed, and I've had kids who are in and out of college. It applies to them too, because here I ran into that situation where my daughter was out of state and I needed to do some banking things for her, and her account couldn't do it because she's over 18. So again, it kind of changes your understanding of this kind of, I guess, preconception that, oh no, it's just when I'm older. So it applies to college kids too, right?
Yes. So actually, TuckerAllen, I think, just wrapped up a college campaign because there's a 17-year out there, and suddenly, magically, on their 18th birthday, they are independent, full adults, and things that their parents have been able to step in and help them with in the past, suddenly they don't have that access anymore. And most people, let's say they're going off to college, you turn age 18, you still want your parents to be able to step in, whether that be for your healthcare or just your finances, help you to continue to file your taxes. Your parents can still help you to set that up. So I would definitely recommend it for people age 18 and over.
And with the healthcare power of attorney, it really is, as you explained somewhat, is finding that right individual who you share your wishes, like, hey, this is what I want done, or I don't want life-saving measures, or if something were to happen, you trust them to make the correct decisions and at your instruction, which really kind of, when you can't say, you already have said, right?
Exactly. So with the healthcare agents, with having a power of attorney, it not only gives you the peace of mind knowing that somebody's there to take care of you, but honestly, it also gives your loved ones the peace of mind so that they have the ease of making those decisions for you as well.
Yeah, it's a tough one to say, well, what would she have wanted? Well, she had that conversation. She's already outlined it, in this healthcare power of attorney, young, middle-aged, or old. I mean, I think it's just right now, and I've had this conversation with all of you, it's like, I can't imagine, it opened my eyes. I'm thinking, I've got kids, and I want them to, make sure they understand what I would want and have to do something. So, we've talked a lot about the durable powers of attorney and the healthcare. Now, everyone knows will. Everyone's heard the word will and a trust, but some get confused with what a pour-over will is. Maybe you can talk about the will and the trust and the pour-over will real quickly.
Absolutely. So in any standard estate plan, we like to think about these two documents, a will and a trust. And essentially, the purpose of these two documents is to either kind of minimize dealing with probate or to avoid probate entirely. I think a common misconception that we often have to dispel with wills is that they don't actually avoid probate. I like to think of a will as merely an instruction sheet to the probate judge saying, hey, if I have any assets that have to go through probate judge, this is what I want you to do with it. And it's also where you can appoint guardians. And that's an important thing to highlight, which I'm sure one of us will talk about more later. But other than that, though, you're not really achieving the probate avoidance goal with just having a will. So that's why we encourage most often for people to create a trust as well. I like to think of a trust as this basket. And then when you go ahead and do your homework and make sure your assets are all tied together into this basket, anything that's in this basket is not going through probate, which is a lot more efficient administration. And you don't have to deal with all the downsides that come along with probate. And then a pour-over will, that's just a fancy term for your last will and testament. It's a regular will, but why it's called a pour-over is because of its function. Just like I said how a will is an instruction sheet to the probate judge, your pour-over will essentially is saying, hey, probate judge, anything I forgot or left out of the basket, pour it over into my trust.
Yeah, I've had many conversations with people exactly saying what you just said and make the mistake of thinking, well, I've got a will, I'm covered. Well, the last thing I want to do is pay an attorney more money or have on my death, whatever I have left being eaten up by attorney's fees, which is what happens when you don't have a will, right? It's got to go, as you suggest, to a probate court where a judge has to divide whatever you have, right?
Yeah, so Missouri actually requires that you have an attorney to carry you through the probate process. So you have to hire an attorney, and there's set statutory fees in Missouri just to administer your assets through the probate process, depending on the size of your estate. So that's significant time and cost that you could save by kind of preemptively creating a trust instead.
So it's easy, you can hear these ads online, or I can use software online and, oh yeah, I got a will. We're good. I'm traveling. I'm good. Well, you're not. I mean, I think it's kind of a one step. It's similar to, okay, step one, we've got the durable powers of attorney in my healthcare. Step two, I've got the will. Step three, I've got a trust. You can do each step, but the idea is to be really comprehensively covered. And I think, again, as we talked about right before the break, and with that young couple talking about, hey, it's one fee, and it really is peace of mind. You're done, and you don't have to worry about it. And it's not, someone told me I got a will, and I think that's a good point. So Kevin, let me, go to you, and I have a question. We talked about, the durable powers of attorney, the healthcare, but many people watching right now and listening, they don't have those. So what happens when you don't have those?
Sure. So if you didn't have a durable power of attorney, what would happen, or what often happens, the rules vary some state to state, but generally what will occur is that the court is going to step in, and there will be some sort of hearing, and there's a process. And at the end of that process, the court is going to appoint someone to make financial decisions for you. And there's a couple of disadvantages to that. One being that it forces your family and friends to go through a often time-consuming and just resource-consuming process of getting this done. And then the second, more obvious disadvantage is that the court's making the decision for you on who they think will make the best financial decisions, instead of you appointing that person yourself.
So there's this word that's always, I've heard, conservator. Is that what this court appoints to handle your financial issues, or what? How does that work?
Yep. So the word that the court will use is that they are going to appoint a conservator for you. And what a conservator does is that they are going to be the ones making those financial decisions.
They're not free, I assume, right?
No, it's not. It's not free. The process isn't free. Nothing about it is free.
I mean, I think the whole point is we talk about estate planning with a purpose, and I thought that was a really interesting title, was kind of, let's have a purpose to make sure we get some of that stress, take care of the relief. And that is, again, these simple instruments that we've talked about, the durable power of attorney and the healthcare, and we'll talk about will and a trust, can really set your relatives, those that remain afterwards, or even during your incapacity, now you know what to do, and they can actually help you, and they don't have to charge you, right?
Correct. So oftentimes if you have a brother or a sister or a child or a spouse as your conservator or your financial power of attorney, they aren't going to charge you for their work. Whereas if a court appoints someone for you, they oftentimes are going to charge you for that work. And then just the process of going to court to get that done that also costs money.
I mean, it's stressful enough to have a loved one either in the hospital, can't make the decisions. Now you've got to go to a lawyer, you've got to go to a court. They don't know you, they don't know them. Again, that's why we started here. And I thought it was so interesting, and especially when it relates to kids and college, and we think, oh, we don't need it, but it's wonderful. But let's talk about the healthcare power of attorney. So what happens, particularly on health decisions, when someone hasn't executed it and someone's got to make decisions? What goes on in a hospital, with a doctor, with your family? Sure.
So what is going to happen in that situation is that each state, there is a list, a hierarchy of people that the doctors to start making decisions for you at that time while you're incapacitated. So oftentimes at the top of the list, if you have a guardian, that would be them, or then a spouse, or then adult children. And what the doctors will do is they'll start working their way down that list until they hit a level where there's at least one person that can make a decision. And so that kind of runs into some issues again if we drop to a level where, let's say, your adult children are the one that are going to be making decisions for you. If you have more than one child, what if they have different ideas of what's best for you? Then there's going to create family infighting, and it's going to slow down the process of just getting the care that you would want or the care that you need, because the doctors are having to deal with these two children with competing ideas.
Yeah. I mean, like, for example, I've got 5 kids, and when we did it, appointing our daughter who's a nurse, and we talked to them and said, hey, there are roles for each of you, and are you each comfortable with your sister making that decision? And I think, they were ecstatic by saying, absolutely. I wouldn't want some of my kids being, going down that list, a guardian, a spouse, adult children, having to be stressed about decisions when they all now know, okay, maybe they disagree, but they've all know what's coming. And I think that's huge. Having that conversation, taking those steps, taking some of the stress as much as you can away at that point, and knowing one person's ready. They know, hey, it's my decision. I know exactly what they want, and it becomes easy. And it's about not just making the decision, as you suggest, Kevin, to get these instruments done, but then having that conversation with your kids, your family, and saying, hey, I've executed this and here's what happens. And now everyone knows, and it's never too early to do it. So maybe what happens then, we've talked about the power of attorney and the healthcare. What happens when you don't have a will? We've talked about kind of when you do have a will without a trust, but what happens when you don't have a will?
Sure. So what's going to happen whenever you die without a will? The legal term for that is you have died intestate. So the states, all states, they have their own intestacy rules is what they call them. It's just a fancy way to say that there's no will, there's nothing there to direct the court on what to do. And so whenever that happens, then there will be a lot of court proceedings. The court has, again, they'll have a hierarchy of people that they will be dividing your assets to. So your spouse or your children or your nieces and nephews. Then as we get more remote away from people that are related to you, then there's a term called heirs at law. So it just kind of branches out fully to just give money away to people, and there's no choice on your end at that. It's the court making all the decisions on who gets what based off of the rules in every state.
I mean, it's an opportunity to, if there are things and items that you want particularly to go to someone, that's the instrument in which you do it. I remember I always tell the story, my grandmother was famous or infamous for using masking tape and putting it on the bottom of everything. And so then we were left to decide, well, she had the worst handwriting in the world, by the way. And we're like, okay, what does that say? Who does it belong to? And now we're fighting over this vase. And well, that's my name. No, that's your name. I mean, it's ridiculous. And I mean, I hated it. I didn't want to be in that situation. And she was just one of those that thought, oh, I've got plenty of time. And she was in her 90s at the time. And I'm like, Grandma, I think it's time. And, I think, now better than ever, I've got things that I want particularly to go to my kids, and each of them know it. Again, it's a conversation. It shouldn't be a surprise, but I don't want to judge trying to decide where it goes and infighting over those items, because I think that would be the worst case scenario. And so I think, again, we talk about estate planning with a purpose, and that's the point, is there's a purpose in what you want done. And I think that you can handle it, and it should be now, because if not now, when? Because now more than ever in this pandemic, that's the point. And so don't forget, as we continue to move along towards the second half, to submit your questions in the Q&A section. I know you have a lot of them, and we want to make sure we get to those today. Go ahead and submit that in the Q&A section with your name and kind of where you live, and we'll try to get that to the panel of attorneys so we can get those answered. We have some questions rolling in right now. So Ryan, I want to talk to you quickly. There was an article in Forbes, and it was called the Go Package. Can you tell me what that Go Package is?
Absolutely, I'm happy to do that. So a Go Package is all of these documents that we've been speaking about, as well as a few others that you have together in a place that's easily accessible and known to multiple people. And it's just together. If there's an emergency, everyone knows where to find it. They know what the documents are. And it's difficult. And that's really the issue. It's difficult to think straight in an emergency situation, or in the worst case scenario, if you're grieving. During the grieving process, you don't want to have to be digging through your family member's house, your loved one's house, trying to find their last will and testament. Or if they're, not in a state of capacity at the moment, if they can't make decisions, you don't want to have to be hunting for that power of attorney document while the rest of your family is standing in the hospital arguing. It is best to have all of these essential documents as well as additional information in one easily accessible spot.
Yeah. And it's interesting you mentioned that, and I'd not heard of the Go Package. I think that's an excellent phrase to be thinking about it. I mean, it really is, it emphasizes the need. Let's go, let's get it done. is that my father-in-law the other day came over and he handed me a packet. And he said, just in case, everything that you need to know, passwords, our will, our trust, our durable powers of attorney, our healthcare, it's all here. So if you need it, it's there. So we put it in the safe. And I just didn't think about it. And here now I haven't done it. So I got to get my Go package together because, again, like you said, I don't want my kids to worry and scramble and try to find it. And what are all my passwords? And there's a saying I was just looking at, it says, nobody ever plans to fail. They simply fail to plan. Pretty straightforward, isn't it, Ryan?
Absolutely. Yeah. I think I learned that one back in high school, where if you don't have something in place, that's when things can go wrong. If you have not put something in place, things are going to go poorly. That there's the potential for argument, there's the potential for needing to involve the court system. If you've planned, if you've taken this time at the beginning to set aside the time, to set aside the money, to get an estate plan in place, to put a Go package together, to tell your family what you want and where it is at, then you avoid a whole host of issues.
And I imagine there are many of us, are new watching right now and listening, someone. They didn't have the Go package. They didn't have a will or a trust or powers of attorney. And your loved ones, your friends are left to scramble, and it's a lot of work. I've watched people go through it and trying to enduring that grieving process, scrambling to get things done, to get bills paid or get accounts taken care of, and not knowing where to look and digging through piles of documents. And boy, that Go package, it's a great piece of advice. Kevin, I imagine this Go package isn't just for, down the road when, you pass away, or it's for accidents and sudden illness like COVID-19. The Go package applies now, doesn't it?
Oh, absolutely. It applies even without something like the current pandemic that we're in. I would still suggest a Go package because you just never know what can occur. I mean, every day bad things happen, and or people get injured, or they like Teresa was saying earlier, even if it's just that you're going on a trip out of the country, it's something that you should have in place. So yeah, I would highly suggest it.
Yeah. Hey, Missy, so we talk about the Go package, and I think we've alluded to kind of what preliminarily kind of what is the Go package, but maybe you can tell people they can get a piece of paper and a pen out right now, start writing down what should be included in the Go package. And again, in my mind, this applies to everyone. There are no requirements. You don't have to have things. You don't have to be married. You don't have to have kids. You don't have to be old. You don't have to, old's a relative term now, it's subjective. You don't have to be, anything 18 to whatever, right? So what's in the Go package?
All right, so the big ones to remember are your healthcare power of attorney, which we've talked about quite a bit, your durable power of attorney or your financial power of attorney. If you have a living will, also called an advance directive, your HIPAA waiver, if you have one of those. And if you have a will or a trust, you'll want to put those in there just in case. And then your medical insurance card, your social security number, any personal medical information, like if you're allergic to a type of drug or a certain like latex or something like that, you want to have it all written out there really clearly so that in a panicked emergency state, the doctors know exactly what's going on and how to treat you best without having to remember what your social security number is in the middle of a crisis.
Yeah. It's interesting as I'm thinking about it, I remember my grandmother was one who wouldn't do any of these things, even though we, implored her to do it. But in her refrigerator, think about in a plastic vial, she put like just what her medication was, her medical insurance card, just some personal information. And it was in the back left corner. And actually, now that I think about it, not a bad idea to put it in there. If you put it in a safe and no one remembers what the safe code is, good luck. Got to get a locksmith. Now we all know it's in the fridge, or it's in the freezer, as long as you don't get it wet. But keep it handy, right? Do you want a hard copy and a digital copy? What's your recommendation and kind of what you should do, and maybe give people a copy, right?
Yeah, so obviously we do want a hard copy because the last thing people want to do is try and figure out how to use your flash drive to connect to their computer when they're on their way to the hospital. So hard copy is always a great idea. If you are tech savvy or you have family members that are tech savvy, I also strongly encourage you to have an electronic copy either on the cloud or on a flash drive or even a DVD if you're old school, just so that if something happens to that physical copy or it can't be found, there's always another copy out there. To be extra prepared, if you trust someone, I recommend giving a copy to them. So if you have an adult child that is very trustworthy, you could go ahead and give them a copy of that in advance in whatever form they find most convenient. So if they're a paper person, you can give them a paper copy in a binder. But if they're an electronic kind of kid, then you can go ahead and give them a flash drive or give it to them on the internet.
Teresa, like kind of playing off of that a little bit, you know, what important people, what should you do with that? Who else would you suggest get this material, this Go package or any of these documents? Who else should you give it to?
So I think, I guess to backtrack a little bit in terms of the Go package, it's great to have it. It's great to have it someplace, but just like where your grandma stored it, it's really important for people to know where you store it, right? You can put it in a safe and it's awesome and it's like fireproof, whatever. But if they don't know the code, how are you supposed to actually make sure that your loved ones are going to follow your wishes? Right. So make sure it's in someplace safe, but accessible with an underline under accessible. But in addition to, like, for example, if you name trustees, your healthcare agents, your financial agents, in addition to letting them have access to these important documents, I would also recommend with regards to your healthcare documents to provide a copy to your healthcare providers. So what I like to tell clients a lot is, hey, after we created these healthcare documents to you, next time, your next doctor's appointment, bring a copy with you, ask them to scan it into your electronic medical record so that your healthcare providers know exactly what your wishes are. And hopefully everything's kind of integrated in the electronic medical record system. But just to be safe, if you see different specialists, bring it to your specialist so that in addition to your family, your loved ones, your healthcare providers also have that information.
Yeah, it's huge. I mean, it's funny. When I moderate these with you all, I'm wanting to write down some things I'm learning, and I'm thinking, okay, I've got my will and a trust in my gun safe, but I don't think anybody knows the combo. What good is that going to do? It's fireproof, but it's now access proof. So now I've got to rethink where my Go package is going to go, right? So thanks, Teresa. So keep submitting your questions in the Q&A section right now. And we're going to get to those questions. It's time for the lightning round so we can get to your questions and get you some answers. Again, submit those in the Q&A section right now. You can ask your questions of the panel of TuckerAllen attorneys. You can find more resources of all we've talked about at TuckerAllen.com, including videos and webinars, as well as podcasts and educational tools to try to get you some more information on things perhaps we didn't talk about. But again, nothing can substitute just sitting down with one of the attorneys at TuckerAllen. They can just give you more information. It's well worth your time. You can do it virtually. You can do it via Zoom. You can do it FaceTime. You can do a phone call. Or if you feel it's appropriate, considering health and safety, you can schedule an in-person consult with them as well. You can call 866-335-3375 for all the offices in Illinois, Missouri, and Kansas. So let's get to the questions that we have submitted. We're going to go ahead and talk about those. So Teresa, I'm going to throw this to you. Matt has a question, and this is a common one. Hear it all the time. I know we alluded to it earlier. Why do we need a trust? Do we need one since we have no children? Is there a recommended dollar amount of assets to justify one? And what is the difference between a will and a trust? So I know it's a multiple part question, so let's just start out. Why a trust?
So I think there's a common misconception that only wealthy people who have a lot of assets need a trust, but that's not true. The point of a trust is so that you can preempt probate. You can take care of your assets ahead of time, consolidate everything in this probate avoided instrument so that transfer of assets after you pass away is a lot more efficient than having to go through the court process.
So going on a little bit step further, do you have to have kids?
No, so you don't have to have kids. I mean, I think some people might find having kids creates an extra impetus to make sure that things are transferred more efficiently. But in terms of just taking care of your assets and actually have it go the direction that you want it to go in the most efficient manner, if you care about that, I think a trust is appropriate for you. So.
Right. And then the difference between a will and a trust, and they work together, but what is the difference?
The difference is a will, I guess I referred to this earlier, a will is like an instruction sheet to the probate court. So a will is a document that dictates what any of the assets that are actually going through the court system via probate. So if you don't have anything that has to go through probate, which fingers crossed, ideally you don't, then your trust is the document that governs those assets.
Right. So you've got your will, let's just call it a cup. Is that maybe a good way? And then you take that cup and you put all your assets in it, and then you pour it into your trust, right? Does that make sense?
I mean, yeah, kind of essentially, but I think step one is while you're still alive, put everything into the trust basket.
Yeah,
and then hopefully you don't leave anything out. But if you leave anything out, the cup is there to get whatever is left. Right. And then saying, hey, probate judge, pour it over into my basket. So
I was having a conversation with my oldest, 26 and working, has his own assets. And I said, you have an estate plan? He goes, well, I don't own any real estate. I go, well, that doesn't matter, right? I mean, you can have other things and plan now, and you'll accumulate things over time, and then you put them into the trust over time, right?
Yeah, so a lot of people think that when you create a will and a trust, you need to have all of your assets finalized, because they think that in the trust document or in your estate plan, you mention each of those assets by name. But ideally, we don't actually like to do that unless you have specific directions pertaining to a certain asset. The purpose of that is because we want these documents to be malleable with your life. Yes. And so, yes, you don't have to have a house. Let's say you create a trust and 2 years later you buy a house. Then you create a deed so that you can set up the trust as a beneficiary on your house, but you don't have to change the trust just because you acquire assets later on.
Yeah. So Missy, kind of along those lines, and I've kind of answered maybe one of the questions submitted, which was, do single people, no kids, need any of the documents? So that means durable power of attorney, healthcare power of attorney, a will, and a trust. Do single people, no kids, need those things?
Absolutely. So as Kevin mentioned before, if you don't have a durable power of attorney, then the court is going to be appointing someone to make decisions for you financially or through healthcare decisions. And that is a very expensive and time-consuming process, and you might end up with someone that you totally don't trust to make good decisions for you. And then after you pass away, if you care about where your assets go at all, then you need to have something in place, because otherwise the court is going to decide it and it's going to go somewhere that you don't want it to go. Right.
So Ryan, here's a good question from Evelyn. Evelyn says, will a trust protect your property from agencies like Medicaid? And she happens to be in Illinois, but generally talk about how Medicaid, I guess, works well or in with wills and trusts and estate planning and elder law.
Okay, well, this is a lightning round, and you've touched on a very complex issue with this question, actually. So Medicaid planning is its own sphere. It's definitely a service that we offer here and one that I'm relatively familiar with, but it will be different for every single state. Medicaid is a federal program, but states get to set up their own rules that dictate how Medicaid will function in your state. As far as trusts go, there's actually a special kind of trust called a Medicaid Asset Protection Trust. If Medicaid is a concern for you, that is definitely something that you need to be taking a look at, because a typical trust, what's called a revocable living trust, general trust that most people have, that doesn't protect you from Medicaid. Assets that are held in that kind of a trust are accessible to Medicaid, and without any kind of plan that you've come up with an attorney, your funds have to be spent down to a certain limit before you're even eligible to receive Medicaid help.
So it's one of the things where we talk about you all at TuckerAllen, where you have estate planning and elder law. That's something, Ryan, where you have consultations with people to plan in incorporating how to deal with Medicaid?
Yes, absolutely. We hold consultations for that sort of issue, and it's really broken into two pieces, whether we're doing pre-planning, which is where like now, you've come up with this question, you know it might be a concern in the future, but there's also crisis planning, where we need Medicaid now, or we're moving into the nursing home right now, and there's not a lot of funds. What do? I think I'm going to need Medicaid soon. So we do both of those kinds of plannings. And you can do, through pre-planning, a plan that will save everything.
Yeah.
You don't have to lose a dime. If you get to the point where you're doing crisis planning, we can still save most of everything. We can't necessarily save it all, but we can save most of it. So if Medicaid is going to be a concern, then absolutely come in, make an appointment with an attorney, and we can get you on the right track.
So what you're suggesting is they don't have to spend down their assets if they plan in advance outside of the crisis planning, so they don't have to spend it down, and so that money can go where they want it to go and not necessarily be used to take care of them, when they're in need of some sort of rehab plan, home, or whatever it may be.
Precisely. So Medicaid has what it terms the spend down, which you kind of alluded to there. It's different for each state what that amount is. Here in Missouri, the amount is $5,000. So that means that the person that is applying for Medicaid, they cannot have more than $5,000 to their name in order to apply. Now there's a spousal allowance. So if you have someone applying and they have a spouse who's still living at home, right now they get to keep $128,640 on the dot. That is how much that they can keep at the most. Mm-hmm. But the spouse that's going to need care still has to spend down till their portion is under that $5,000 limit.
Gotcha. Well, it certainly sounds like they need to come in and just talk about it, and I encourage everyone to really, it's an amazing opportunity to try to preserve some of your assets. So let's keep going on. Let me go to Kevin. Kevin, Jenny has a question. Jenny has an old power of attorney. The person that Jenny named to take care of things for her is no longer part of the family. How does Jenny fix that, and can she fix it?
Yeah, sure. Jenny can absolutely fix that problem. So what she would want to do is to come in to see an attorney and get a new power of attorney executed that names someone other than this person. So the last thing that we would want is for something to happen to her right now while we have this person named that she does not, that's no longer a part of the family. She doesn't want dealing with her financial decisions. So we definitely want someone we would want her to come in and get that fixed.
Teresa Albert asks, where would a transfer in payable on death or transfer on death provision fit to avoid probate?
So payable on death and transfer on deaths, PODs and TODs, these are the similar concept, different names for beneficiary designations. So on all of your assets, you can set up a beneficiary. Like we said, for a house, you can set up a beneficiary deed. If you have a trust, you want the trust to be the beneficiary. So there isn't really like a provision for PODs and TODs in the documents, in your estate planning documents, but in terms of avoiding probate, you definitely want to set up, for example, bank accounts, they use the term payable on death, so you would want to set up a payable on death to somebody so that you are the owner of your bank accounts, but as soon as you pass away, somebody is there to catch it. And then we like to have the trust be the entity to catch it, because then everything is just all together in one pot, and then it can be administered efficiently that way.
So it's not the solution or the replacement to a will or a trust, right? You shouldn't rely just on those things?
No, I mean, it's a helpful device that comes along with these assets, but you don't want to rely on it just because, let's say you have 10 various assets, which really isn't that much for a lot of people, just combining everything that you have. Let's say you set up a beneficiary on each of these assets, that you have to make a change. Then you have to go back to each of these assets and make that change, and that can be a really time-consuming and draining process. So that's why if you have the trust set up as the beneficiary, you need to make a change on the trust, and it's a one and done deal.
Yeah, so it's a combination, just like we've been talking about the power of attorney, the durable for healthcare, the will, the trust, combine that with transfers on death, payable on death, kind of a full and complete package where you just step by step get everything done. I get it. Let's go to Missy. Missy, the question's from Catherine. Catherine says, we're in our early 50s and we don't have a lot I'm interested in learning what we may or may not need to do for their children, for her children. They don't have a will. They have no POAs. So they just want to know, what should they do? You know, again, we mentioned this isn't, you know, the misconception is this is only for the wealthy or the people that have things. Should Catherine be doing something now for their children?
Yes. So if we're really interested in protecting the kids and making it as easy for them as possible, the first thing to deal with is getting a healthcare and durable power of attorney for financials in place. So that way your kids aren't left with an overwhelming mess or having to fight through and get guardian conservatorship for you in court if something happens to you and you become incapacitated. That makes it so much easier on your children. And then also planning for after your death, getting a will in place just so that it's clear that you want your assets to go first to your spouse if you pass away, and then to your kids equally if that's what you want to end up doing. A will is a good first step. I know you said you don't have a lot, but really a trust isn't based upon how much money you have. It's about protecting your family and making things easy and cheap for them instead of having to fight through probate. So having a trust sounds like it would be a really good fit for your situation there, just so that they don't have to end up fighting through probate and paying lots of money in legal fees to an attorney and to court. Having it put into a trust means that they can make a distribution much earlier, much faster, and much cheaper.
Yeah. And I think the next question, I'm going to go to Ryan and Catherine. I know you'll be interested in this considering the recommendation from Missy, and that is Ryan Thomas says, what kind of fees are involved with setting up a trust? And are there maintenance fees? And also, what if a change needs to be made? So you can kind of go through generally some costs in the program that TuckerAllen offers in terms of that annual program, which allows for some changes to be made.
Absolutely. So that's a multi-part question here. But as far as generating and creating the trust to begin with, all of TuckerAllen's prices are on our website. You're free to go look at those whenever you'd like. But the typical couples trust that we do right now, trust package includes all of the stuff that we've talked about today that we say you need these things to make a good estate package. That's $2,650 right now, $2,650 to get that package together. And the prices you'll find from other attorneys will vary geographically. But right now, the average in Kansas City is just below $4,000. So we're actually coming in a little bit below that. And we're, you know, you can keep an eye out. We run programs like Teresa mentioned earlier. We did a POA program for students. We've got another one running in Kansas City right now. But we also have maintenance programs. We mentioned how, you know, if you had a life change situation, there's been some sort of change in the law, we have a maintenance program that we call the Legacy Protection Plan. And that is a service where we will keep an eye on changes in the law and anything like that. And if you come in and you want to do updates to your document or changes, that's covered under the pricing for the maintenance plan.
Yeah, and that's key. That's huge because, you know, as even younger couples come in or individuals, singles, life changes. And it could be, as, you know, suggested that Jenny talked about a POA change. Those are things that would be covered under that legacy plan, right? Just, you know, the kind of the single changes annually or something that happens, life change that would be covered.
Absolutely. Those kinds of changes are covered underneath the protection plan.
And I think you also mentioned the Secure Act, I think was something that was an update and something that's important to incorporate into plans that were drafted prior to it.
Absolutely. So that was a big change that just came through and is hitting everyone in 2020 now. If you have an IRA and you have incorporated the IRA into your retirement planning and your estate planning, then you probably need to go back and take a look at your estate plan to make sure that it has taken the Secure Act into account. There's still a lot of debate around this topic amongst the legal circles on what the best way to do this is, but it is agreed by everyone that you need to re-examine your plans and make sure that the Secure Act has been taken into account.
So is that something that you, all of you would specifically, I'll just ask you, Ryan, consult with people regularly about the Secure Act, and for those who already have their documents drafted, about amendments and you know, changes to their plan?
Like I said, if they've got an IRA as part of their plan, then that's something that we will absolutely talk to the client about, because that's where the main area of impact for the Secure Act is. And I'm going to go off topic for a second because there's something that I'd wanted to mention previously that I just didn't get a chance to. As far as all of these estate plans are concerned, there are a lot of special considerations that need to go into place if you've got anyone with special needs in your family, or if they're going to be inheriting from you in any way, even if they're not members of your family. And those guardianship, conservatorship situation versus the POA comes into play as far as special needs children are concerned. So they're hitting 18, they might not be going off to college, but you as the parent are still going to be taking care of them. That's definitely a service we offer. We make sure that we go through with you on getting a guardianship and conservatorship so you can still take care of your child.
Yeah. All right, let me go to Missy. This is from Ben. Ben asks, what happens to my kids if I don't have a will that includes guardians' names or someone that they should go to? Do they just go to family members like Ben's sister?
All right, so it kind of depends. If Ben's married and the spouse hasn't lost custody, then if Ben passes away, Ben's kids would go to his spouse or ex-spouse, the biological mother of his children. If that spouse is no longer in the picture and both predeceased, then those kids are going to have to go through the court process, and the court will hear petitions from anyone who's interested in becoming their guardian. And then that's kind of quite a court battle there. There'll be a home study to make certain that anyone that's putting themselves forward has a suitable home environment. And then ultimately the judge is going to make the decision. If the kids are old enough, they'll talk to the kid about their personal preference, but ultimately a child's personal preference on that may not be super reliable, and the judge is going to make its own independent decision. Yeah. So it's just a recipe for conflict.
Yeah, absolutely. Teresa, Jamie has a question. Jamie says, what should a complete estate planning package for a married couple with 4 elementary age children consist of? Then there are 2 other parts to that, and I'll wait before I get that. What should the estate planning package with those elementary age kids include?
Well, pretty much exactly what we've been talking about. We would say if you have 4 elementary age kids, number 1, you want a will, because wills are those documents that include guardianships, right? So you want to make sure you have something in place so that somebody is there to take care of them. Okay, so you want wills for each of mom and dad, but you also want a joint trust for mom and dad, so the mom and dad can make it, if something were to happen to the 2 of them, assets can be transferred without having to go through probate. And of course, we would want to set up the powers of attorney just so that we're really covering them comprehensively. And there are options when you have elementary or minor kids in terms of setting up an estate plan about how the distributions can best be made or best be set up inside your trust document.
So Jamie also asks, how often should it be modified? And then I'll ask the last part, and you can answer them both. Mm-hmm. How long does it take to complete the process, start to finish? So how often modified, and how long will it take when Jamie comes in?
So for how often it's modified, standard practice, I would say at least like maybe a couple of years visited, but really that's where our maintenance plan really like kicks into place, because then there's just this built-in structure where your attorney will check in with you every year being like, hey, let's just do a quick annual review. It won't take too long. Is everything still good with you? Especially when you have 4 minor kids. That's really helpful because as their kids are growing up, it's more likely that you'll want to make changes. For example, as your kids become adults, you might want to change your trustees to your kids rather than a separate family member or something. In terms of how long it takes to create these documents, normally it takes us 2 weeks roughly to get these drafts done. From when you walk into our door, we do a consultation. We get the drafts to you in 2 weeks, and that's your opportunity to review those documents, ask questions, make changes, and then we have that signing at whenever you feel comfortable to go ahead and execute those documents.
Yeah, and I can tell, just having been a client, it is really easy. You get it electronically. You have this login into the TuckerAllen system. You get to see the documents. You get to read them, sit down in the comfort of your home at your timing, not having to come in and feel pressured and not have questions. And you get to reflect on the changes. It's really seamless, and I like it. But Teresa, you mentioned this plan. Again, I know that Ryan had mentioned kind of the legacy plan, and then you had suggested changes every couple of years. That meeting, I think you alluded to it, coming in at one point, that's included in the plan where they can just come in, no additional cost beyond that plan cost, right?
Yes, so the plan includes no additional cost, an annual review to make sure that everything is up to date, whether it's to update legally because of something like the Secure Act or because something in your life has changed.
Yeah, I thought that was really interesting just because you don't see it a lot. And the last thing you want to do is spend $2,600 and then have to spend another $2,600 in 5 years. And that's the whole, I think, unique part of that plan, which I like. So let me go to Kevin real quickly. And I'm not sure if we asked this one, is it maybe additional question is, how does one change the executor on their trust? Is it a simple amendment, Kevin, or how do they do that?
Sure. So an executor is more often a term that's used for a will, but if the kind of counterpart to that would be in a trust would be your trustee. And it's an easy amendment to make. So if you would come in and you wanted a new trustee for your trust, then it's just one document. It's a short document. So there's a provision in your trust that allows amendments to be made. And you cite to that, and then you make the amendment, and that's it. It's all done. It's a very quick and easy process to do that.
And it's actually, if it's something you and part of that legacy plan that I think Ryan and Teresa mentioned, it's covered. That one change, something like that. I think it's an annual or something to that effect. So I would encourage people to check out that information more about it. But thanks to the panel today, we've run out of time. I know we had more questions to get through, but thanks to the panel for joining us. Appreciate it. So if we have those questions that we didn't get to, we'll get to those during the podcast that we do every week. So check that out. We'll devote more of the podcast to getting to the remainder of the questions that were submitted today. And obviously, if you have questions as a result of hearing and listening to our panel today, you can reach Tucker Allen at 866-335-3375, covering all of Missouri. We've got Illinois and Kansas. So we've got offices throughout there in Overland Park, Kansas City Independence, St. Louis, Kirkwood, and over across in Illinois. Again, TuckerAllen.com or 866-335-3375. Check out the website. You'll get more resources, more information in addition to what was told to you today. Encourage you to seek out a consult, whether it's with TuckerAllen.com or Tucker Allen or not, or with someone who just practices exclusively in estate planning and elder law. Thanks for joining. Continue to look for more information like this and more virtual webinars where we'll bring you the information that you need and the questions that you have and get those answered. Thanks for joining. Until next time, have a great week.